Ma'am, respectfully, Your Honor, I could not hear you.
It's no respectfully. No. Respectfully, Mr. Kennedy. Look like you need to come to court in person. Now, I got a feeling we might have gone through the same thing the last time you came.
3 separate criminal cases, 1 impatient judge, and a defendant who just can't seem to sit still. Welcome to the 36th District Court, where Judge, with her no-nonsense style, is about to have her patience tested to the limit. Today's defendant, Marvin Kennedy, isn't just facing 1 aggravated assault charge, he's juggling 3 of them. This is supposed to be his final pretrial conference, but before the legal arguments can even start, the judge is forced to address something much more basic: his inability to stay seated and follow simple courtroom instructions. Over the next few minutes, you'll see the tension build, the judge's tone sharpen, and the stakes rise higher than ever. By the end, there's a clear message: this court plays by strict rules, and if you can't follow them, there are consequences waiting just around the corner. Buckle up. This hearing is about to escalate fast.
We're all set with Mr. Hood. Have a great day, sir. Stay safe.
All right, you too.
All right, thank you. I'm ready on Kennedy. This is case number. Ms. Kennedy, I need you to be still. Mr. Kennedy, I need you to be still. This is case number. These are case numbers. The defendant is charged with 1 count of assault aggravated. Today is the date set for final pretrial conferences as to each matter. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Your Honor, Austin Gregory, P85193 on behalf of Mr. Kennedy, who's present by Zoom. Mr. Kennedy, please unmute and state your full name for the record. You have to unmute first, Mr. Kennedy.
You have to be still too. This is too much. This is too much, Mr. Kennedy. It's a table over there. Can you go sit down at that table? This is too much. Oh, blessed assurance. Oh, did I say that? Oh, I said that. Oh, okay.
Right there with that microphone. You should be able to hear it.
Hello? Can you hear me?
Yes, Mr. Kennedy, please state your name for the record.
Thank you. My name is Marvin Kennedy.
I've been wondering, can you hear me? Because if you can
Yes,
hear
ma'am.
me, well, you're certainly not following my instructions.
Ma'am, respectfully, Your Honor, I could not hear you.
It's no respectfully. No. Respectfully, Mr. Kennedy. Look like you need to come to court in person. Now, I got a feeling we might have gone through the same thing the last time you came. Well, let me say this. 36th District Court is open. We're open for business.
Okay.
What I'm not going to do is wait for you to walk from your house to your porch, from the porch to the yard, I'm not going to do that, Nick. I am not going to do that. Now you need to be ready for court. I'm certain that I said earlier, remain stationary.
Yes, ma'am, you did.
Right. I know I did. Please don't interrupt me. I said remain stationary. Seated in an upright position, ready to attend court. You did not remain stationary. You were not seated in an upright position and you were not ready to attend court.
Right here, you can see why judges emphasize courtroom decorum, even on Zoom. Remain stationary isn't just a polite suggestion, it's a command. When you're facing multiple serious charges, every detail of how you present yourself matters. The judge is pointing out that Kennedy isn't just distracted, he's undermining the seriousness of the proceeding. This isn't just about respect, it's about maintaining order so the court can operate efficiently. Viewers, here's a question. If you were the judge, how many warnings would you give before taking action? Drop your answer in the comments.
I'm not going to do this with you again. Next time, I'm going to delete you from the screen and a warrant is going to go out for your arrest. You need to come to court in person. Mr. Gregory, how are we proceeding today with these 3 cases? All of them are scheduled for final pretrial conference.
Your Honor, we are asking that these not guilty plea be continued and that they be set on track for a jury trial.
Well, okay, and I'm gonna give him a jury trial too, because this right here is too much. It's too much. And he has 3 cases and we're going to trial. And we're going to trial this year. When is Judge Garrett coming back? Let me call. Y'all don't know. I wasn't asking y'all. Don't worry about that. I'm gonna find out because I'm gonna take one of his jury trial dates. Hold on. Because this right here is too much to take into the new year. All right, September 27th. When is the last time the people's witnesses came?
Judge, it is the same complainant witness for all 3 cases, and she appeared on May 26, 2023.
Great. Call her. Tell her September 27th. She on queue for three trials. May. I mean, what girl? I went back to May. Because that's what you said she came. September 27th. And then let me be clear.
And here's the turning point. The judge makes it crystal clear. One more slip up, and Kennedy's going to find himself physically in court, whether he likes it or not. In legal terms, she's warning of a bench warrant, meaning law enforcement would bring him in. Remember, he's got 3 separate cases hanging over him, and the prosecution isn't backing down. Instead of a plea deal today, they're pushing these charges toward a jury trial. That's a huge risk for the defense, because once a jury is involved, there's no predicting exactly how they'll weigh the evidence.
If there is an offer on the table from the people, it expires on August the 30th, because then they're going to bring in the juror. They're going to summons those jurors for me for that special day. And after that, it's no offer after the final pretrial conference, August 30th at 9:10, and jury trial September 27th. Anything further?
This is one of the most critical legal moments in the hearing. The judge sets a hard deadline, August 30th. That's when any plea offer from the prosecution will expire. After that, the case moves into full jury trial mode on September 27th. Why is that so important? Because once that offer is gone, the defendant loses the chance to negotiate a potentially lighter sentence. It's like a ticking clock in the background. Every day that passes without a decision makes the risk of trial even greater. Imagine having to make a life-changing legal choice under that kind of pressure.
No, thank you, Judge.
Nothing further, Your Honor.
All right, then, Mr. Kennedy, you're all set. And on August the 30th, the hearing is in person. So put that at 9:12. That's in person. It's too much. It's too much.
That's
All right, anything further?
Nothing further, Your Honor.
I'm sorry, I didn't know if I heard Ms. Ritter. That's why I said that. I'm sorry.
Oh, I'm sorry, Judge. Nothing further from the people.
Okay, then we're all set until August 30th. Have a great day. Stay safe.
So let's recap. Marvin Kennedy appeared before the 36th District Court facing 3 separate aggravated assault charges. What should have been a straightforward pretrial conference turned into a showcase of the judge's frustration over his lack of courtroom discipline. She issued repeated warnings, made it clear that in-person attendance might be next, and locked in trial dates with no room for delay. With a plea deal deadline looming, Kennedy has a tough decision ahead: negotiate now or roll the dice with a jury. If you found this case as fascinating and frustrating as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.